Good morning and a very happy Monday. Thanks for joining us for the first of our week-long Brexit webinar series. We'll be looking at some of the key legal points you need to be aware of in preparation for the end of the Brexit transition period. When on New Year's Day, the 1st of January 2021, we will welcome a new beginning for the UK. So today I will be looking at some of the key data protection issues for you to consider, and I'm also joined today by Colin Miller, who's going to look at some of the key issues to protect your intellectual property. Over the week, you will hear from our expert teams who will cover all of the key issues that you need to know, including tomorrow we're looking at commercial contracts. On Wednesday, we're looking at immigration and the end of free movement of people. Thursday is trading, imports, exports and tax issues. And on Friday, we're looking at some regulatory changes that businesses need to be aware of. So please make sure you tune in between 9:30 and 10 every day this week to get the lowdown from our fabulous teams. So a couple of housekeeping points just before we crack on. I'm sure you'll be very familiar with these housekeeping points already, but if you can please ensure your mute button has been selected and to remain on mute to limit any background noise, that would be great. And if you have any questions, please feel free to use the chat function to direct these either to myself or to everyone. We may not be able to answer all of the questions, but we will certainly try. All the questions will be anonymized, so we can record the webinar and distribute it afterwards. So just a reminder that the session will be recorded and available to everyone. So let's crack on. Data protection. We're going to look at some key data related considerations. As the end of Brexit transition period approaches, it is important to consider what impact, if any, it may have on your data processing activities. And in this session, there are 3 points that I'm going to cover, which I think is probably going to be of most impact to our audience today. They are, firstly, what laws will apply? Second, data transfers. How can you keep your data flowing to and from Europe once the UK leaves the EEA? And third, we're going to cover some practical steps you should be taking now in preparation for the 1st of January. So what laws will apply? This is a question we get asked a lot. Will the GDPR still apply? And I think actually secretly some of these questioners are hoping that the GDPR will not apply. We'll not hear about anything to do with GDPR going forward, as it's already got a lot of airtime over the last few years. Sadly for them, as with the word Brexit, I think we're likely to be hearing continued references to GDPR and indeed Brexit for many more years to come. Although I did hear this morning that the word Brexit has dropped 80% in terms of usage in the last year, so we'll have to wait and see. There are some differences though. So substantially the same requirements will apply in the UK, but a UK GDPR will replace the EU GDPR from 1st January 2021 in the UK. So in the UK, the 29 regulations consolidate and amend EU GDPR and UK Data Protection Act 2018, which supplements GDPR and UK law to create this new UK GDPR. So the UK GDPR will apply to processing of personal data if you're located in the UK, or you offer goods and services to or monitor the behaviours of individuals in the UK. Whereas the EU GDPR will continue to apply if you have branches or offices in the EEA, or you offer goods and services to or monitor the behaviour of individuals in the EEA. So 2 separate regimes. So for businesses with offices in the UK and the EEA, who offer goods and services outside of the UK, you will need to comply with these 2 separate data protection regimes. And as the UK law is substantially the same as EU GDPR, most businesses will probably not notice any massive difference from a day-to-day compliance perspective. However, that doesn't mean you should rest on your laurels, and there are a number of areas which we'll touch on which you need to be aware of. One practical consequence for businesses operating cross-border is that if you are subject to EU GDPR, then the UK Information Commissioner's Office, the UK ICO, will no longer have the authority to deal with EU GDPR compliance. It's no longer part of that regime anymore. So at the moment, if the UK ICO is part of a regulatory one-stop shop. So for UK businesses, you could notify the Information Commissioner's Office and they would be your lead supervisory authority. While the ICO has indicated that it intends to continue collaborating with other European supervisory authorities, it will no longer be part of that one-stop shop mechanism. So that means you may need to reconsider the location of your lead supervisory authority or whether you have one in the EU. So if you've notified with UK ICO in the past, you may need to consider notifying with an alternative supervisory authority based in the EU. If you have other offices in the EEA, for instance, then that decision may be fairly straightforward. You might want to align your business to the lead supervisory authority in the territory in which you're based. However, if you do not already have a physical presence in the EU and will continue to offer goods and services to or monitor the behaviour of individuals in the EEA from your base in the UK, then you'll need to take steps now to identify a suitable lead supervisory authority. So some of the questions you might want to consider is your processing likely to affect individuals only in one country or across the UK or in multiple EEA countries? Where do you make the main decisions about your data processing activities? And where do your main processing activities take place? These sort of questions might help you to come to a conclusion about whether you need to align yourself with another supervisory authority and where. The second point I wanted to cover is transfers of data to and from Europe. Most businesses are likely to have an existing flow of data to and from Europe, whether as a result of maybe the territories in which your business operates. You may have branch offices, subsidiaries, or group companies established in other European countries. You may deal with customers, suppliers, or partners who are based in Europe, or you may outsource some of your data processing activities to a third party who's based outside of the UK, typically sort of payroll activities or maybe IT support. Or you may back up your data to the cloud with servers based in another country. So all of these things involve transfers of data outside of the UK. Whatever it is, there are steps that you need to take to protect the ongoing free movement of and flow of data. So we hear a lot about the free movement of goods and services and people, but the free movement of data is equally as important for many businesses. The main takeaway from this point is that the UK might not be regarded by the rest of Europe as having an adequate level of data protection come Brexit Day, which will impact the ability of companies to transfer data. Certainly just now, it seems highly unlikely that the UK will receive an adequacy decision from Europe prior to exit day. Now, that does seem a bit harsh because UK law is pretty much entirely based on the EU GDPR, and it will become 1st of January. However, like so many parts of the separation arrangements and the new working relationship with Europe, this is something that has not been fully debated and finalised yet. It falls into the sort of no-deal scenario bucket of problems, as you will hear throughout the week, and it's just one of many unanswered questions. So what can you do? I think you should consider the following, particularly in relation to data transfers. Do you transfer personal data to the EEA? Now, curiously, the one-way transfer of data from UK to EEA is actually protected under UK GDPR because UK has already recognised that the EEA offers an adequate level of protection for that flow of data from UK to the EEA. But we all know that data doesn't flow one way to tends to flow two ways or different ways. So next question is, do you import personal data from the EEA into the UK? And then do you make onward transfers of EEA data within the UK? So these are also questions you might want to ask when you're looking at your data flows. Assuming the EC has not recognised the UK as having an adequate data protection laws, then in order for transfers to continue, you'll need to implement some measures to safeguard the protection and flow of that data. So probably the best example is using and incorporating the EC standard contractual clauses, or SCCs, into your agreements and arrangements. The SCCs are the most common safeguard that businesses already use to transfer data outside of the EEA to other third countries. But they can also be used to transfer data from the EEA to the UK post-Brexit, which will be regarded as a third country by Europe until an adequacy decision is made. So in the same way we're transferring data out with the EEA at the moment to third countries, we're using these standard contractual clauses. That's what we're suggesting you ought to put in place for transfers from the EEA to the UK. So some points to consider is, do you have appropriate flow down terms in your contracts? Do you make onward transfers of data of EEA data, difficult for me to say in the morning, to other non-EEA countries? Or so if you do, you'll need to assess and ensure you have adequate data transfer arrangements in place for all the relevant data flows. Now, anyone in the world of data protection knows that international data transfers are a very, very hot topic in the world just now. There are a number of different forces at work, which will mean there's a lot of focus that will be shown on international data transfers over the next few months. The recent Schrems II decision ruled that the EU to US Privacy Shield was invalid. You probably heard that over the summer. So Privacy Shield was a very specific transfer safeguard that regulated the flow of data to and from the US. It was just US specific. So if you previously relied on EU to US Privacy Shield to export data to the US, you must ensure you put something else in place now. And many companies are adopting the standard contractual clauses, SCCs, we talked about already. The SCCs themselves are also in the spotlight, as they're 20 years old and are slightly creaking around the edges, principally as they've not been updated for the GDPR era of data compliance. So the EU has recently issued new draft standard contractual clauses that are out for consultation at the moment, which are a big leap forward from the current SCCs, albeit they are not perfect and they do raise some interesting and tricky data protection queries in their own right. However, the consultation on those is open until the 10th of December, and it's highly unlikely that the new SCCs will be adopted before the 1st of January. So for the time being, the existing standard contractual clauses is what you should focus your attention on. Also, to make things even more interesting, the EDPB, the European Data Protection Board, recently published guidance on certain supplementary measures that should be taken to protect international data flows. So these are even if you're using the SCCs. This puts a lot of pressure on data exporters to carry out a legal analysis to ensure that any flows of data to third countries, the recipient country must have essentially equivalent protections in place to protect the data within their local jurisdiction. So I think that's going to put a much higher regulatory and compliance burden on all businesses and data exporters that transfer personal data outside the UK or indeed outside the EEA. And if the third country's laws are not deemed essentially equivalent, then we're being told that the data transfer should stop or should not proceed, not go ahead. So you can imagine if data flows are brought to a crashing halt, that may have a big impact on our businesses and our way of working. So lots of moving parts and things to think about there. But for the time being, the standard contractual clauses, warts and all, are the ones to continue to rely on. The important thing is, if you don't have a valid transfer mechanism in place and you're not protecting personal data you're responsible for, you could lay yourself and your businesses open to fines and claims. Finally, in the last minute, the third point I want to cover is practical steps. I think most of you will say, what can we do? What can we do now to solve some of these issues? I think the most obvious thing to consider is any contractual updates. Data protection elements of commercial contracts may need to be considered and may need to be updated to reflect the fact that the UK will no longer be part of the EU, and we want to include these data transfer provisions we just spoke about there. So consider what documentation needs to be updated or replaced. For example, you may wish to change the applicable law. You may wish to manage contractual requirements such as data protection warranties, and you may want to update your documentation to deal with data transfers, etc. Other things to think about which will probably be impacted would be, now's the time to review your privacy policies and notices to make sure that they are updated for the new UK GDPR. We've talked about updating your agreements with third parties, suppliers and others. But there's lots of other policies and things you might want to revisit now as well, including maybe your processing records, your data privacy, impact assessments, and other documentation. So lots to dig out and consider. So just to summarize, we've looked at the relevant laws that will apply, we've looked at international data transfers, and we've looked at some practical steps to take. So with all that is going on right now, you might want to buy your data protection team an extra present for your virtual Secret Santa present exchange coming up in the run-up to Christmas, because I think they'll need it. And with that, I'm going to hand you on to Colin, who's going to talk to you about some IP issues.
Okay, thank you, David, and a very good morning to everyone. As David mentioned, I'm Colin Miller and I specialise in commercial contracts and IP. So I'm going to say a few words this morning about the implications of Brexit for IP. So just to clarify, I think when I'm talking about IP, I'm just really referring to a group of different rights which may be important for some of you listening in this morning. So you may have patents for your inventions, or maybe thinking about filing patent applications. You may have trademarks for your brands, design rights for your products, or perhaps copyright in software that you are developing or you use in your business. So all these attract IP rights. And the first thing I'd like to say this morning is actually share some good news with you. And there's not much of that around at the moment. So the good news is that come 1st of January, nothing much is actually going to change in terms of the UK substantive laws. So they will actually remain pretty much in place. And most of our UK laws, as many of you will be aware, are actually based on EU legislation. So much of this will remain the same. So I'm just going to attempt here to share some slides with you. I don't know if they're going to come up. Yeah. So I'm just going to have to go back the way. If you just excuse me. So here we go. Right. So as I said, substantive law will remain the same. But there are one or two things I'd like to mention in terms of EU-wide IP rights. So I think these are important for those of you who are already trading in the EU, or you're thinking of doing so in the near future. And some of you may already have a registered EU trademark or a registered community design. So again, good news here, existing EU registered trademarks. So that's a trademark that's valid throughout the entire EU. That will no longer apply to the UK, but the good news is that the UK is automatically going to create a new comparable UK trademark. So there's nothing you actually need to do, no further costs to be incurred. And that's also the same for existing community registered designs. So those will no longer cover the UK, but you will automatically obtain a new comparable registered design. So that's all good. And similarly, if you're in the process of filing an application at the moment for an EU registered trademark or a community design, or you're thinking on doing so, then certainly if it's already filed, then you will need to make a separate application for a separate UK mark. But the good news is, again, you will be given an extra 9 months to do that, and you will still get the benefit of the original filing date for your European application. Again, in terms of EU-wide rights, there are also some implications for unregistered rights. And I've highlighted a couple here that are important, again, if you're trading in the EU and you have those rights. So one is unregistered community design rights, slightly different from the equivalent UK design right. But the good news, again, is that if you have unregistered community design right in your products, that will continue automatically by way of a UK equivalent at the end of the transition period. Now, I don't know if many of you here today have databases, might be a valuable asset in your business, and as some of you are probably aware, IP rights do exist in databases, and this came into force in the late 90s as a result of developments in the EU, and recognition is given to people, to owners of databases, and they're given an anti-copying right to stop others from copying databases. And that obviously comes up a lot with customer databases or databases which deal with complex development of products. And in those cases, often people leave businesses and they go off and join competitors. And it is a very valuable right, I think, to have in a business. And the good news, again, is that come 1st of January, in the UK, you'll be given an equivalent UK right with the same period of protection. So if you've got an existing database with existing database rights, those will continue until the period expires, which is 15 years from the date of creation. I thought it'd be worth mentioning this issue of parallel trade, or exhaustion of rights, as it's sometimes known as, because this is going to be affected by Brexit. So that's important for any of you today who are exporting to Europe, or who have distribution networks in different member states. Now, you may remember, just from listening to the news, the press, that all the debate that's been going on in Brexit, that one of the basic principles of the EU is the principle of free movement of goods. Well, of course, this is going to end and will no longer apply to the UK. And one of the IP implications of that was that if you owned an IP right, say a trademark or a patent, and you sell goods in the EU, then you're deemed to have exhausted your IP rights in the EU, and you cannot use IP rights that you might have in other countries in the EU to stop goods coming into those countries. So perhaps a good example of that would be if you were a whisky distiller in Scotland, say Morrison Bowmore Distillers, which is now part of Beam Suntory. So they've got the famous Bowmore brand. So if they sold to a distributor in the UK, or maybe a wholesaler, then they're deemed to have exhausted their rights. And that meant that the wholesaler was free to sell those trademarked goods anywhere else in the EU. And Morrison Bowmore, or Beam Suntory now, would not be able to use, say, their French trademark or their German trademark to stop those goods coming into France or Germany. And the EU was a strong proponent of parallel trade, and lots of people benefited from this, particular distributors, because they were able to take advantage of price differentials in different member states and to go in and undercut distributors in other member states. So the prohibition of restrictions in parallel trade will no longer apply. And I think this means that if you're exporting trademarked or patented products to other member states, you now may need to get the consent of the IP rights holder to export those goods into other member states. So what are the tips I can give you this morning? Some brief tips on IP in terms of when we're looking at Brexit. Well, I think one obvious thing is that if you have some important contracts in place with distributors or with licensees, then I think you should have a look at the contracts, particularly the definition of territories, or anywhere where you've mentioned the EU or Europe, because the UK now will no longer be part of that. And the last thing you want is to get involved in a dispute at a later date over restrictions on the territory, or over whether, for example, the UK is or is not part of the territory. So it's time to have a look at that. In terms of registered rights, so you remember I talked about registered EU trademarks and registered community design rights. So if, as I said, the benefit of this is you will automatically get a UK equivalent right. But if you're in the process of filing a trademark application or a community design right application, then see if it's possible to expedite those before the year end, because that will avoid you having to file new applications for the UK. As far as unregistered rights are concerned, I think it's important to realise that certainly with unregistered design rights and databases, you're going to have UK equivalent protection. So bear that in mind, that you will have the rights to take action against infringers in the UK after the 1st of January. And as I've mentioned, parallel trade and exhaustion of rights will no longer apply. So if you're exporting trademarked or patented goods to the EU, you may need the consent of the IP owner. Now, I've really just talked about some of the main laws. I've not focused at all on enforcement and litigation. There will be some changes to that. And if any of you have any specific questions on that, could I refer you to my colleague, Colin Hume, who is the partner who heads up the contentious IP litigation practice at Burness Paull, and I've included his email address there for your information. So that's all I'm going to cover this morning. Hopefully that will give you some positive news anyway on the IP front. And I think we're just going to have some questions now, either on data protection or on the IP. So I'll just take this.
Thanks.
Okay.
Thanks, Colin. We have one question that's come in on data protection. So how can you find out which countries do not have adequate GDPR laws? So this is a tricky one, and at the moment it's not absolutely certain how this is going to be dealt with, but really the responsibility at the moment is on each data exporter to carry out their own legal assessment of the relevant third country where the data is to be exported to. That means really assessing the local laws of that territory and probably getting local legal advice. Now, in the same way that the European Commission has stated which countries are adequate in the past, the hope is that there will be some sort of blacklist or some sort of a method or methodology or consensus in relation to third countries going forward, but we're still kind of up in the air a wee bit on that. I'm not sure if there's any other questions coming through just now, but hopefully that answers everything. Just to say, look, we'd be delighted to answer any other questions you may have offline. This is meant to be a quick fire through half an hour session, so apologies if we've not been able to respond to your question. But hopefully you found this session interesting, and please feel free to catch up with either myself, Colin, or indeed Colin Hume on any of the issues that presented. And hopefully see you for the future sessions later this week as we cover the rest of the Brexit issues that are relevant to your business. Have a good day. Thank you.